Well, hello everyone. We should be making a start now. So a warm welcome to you all, and thank you very much for joining us this afternoon. If you haven't joined us before, we always start by making a brief introduction so you know who you're talking to. So for those of you who have, then please just bear with us. But as I say, just so you know who I am, I'm Karen Falconer, and I'm the HR Knowledge Manager at HR Solutions, and I'm going to be the lead presenter today. And I am joined by my colleague Ateem, and she is our digital marketing executive. So she is here just in case you should have any technical problems. Hopefully, of course, there won't be any. But if you do have any come up, then you can use your control panel just to send her a question, and she'll see if there's anything she can do our end to support you. But if not, then we'll try and see what we can do afterwards for you. We do record this session, so it will be available for you to watch again. You can also then, of course, share it with your colleagues. And we also make the slide deck available on request afterwards too. So if you think you would find that helpful, then please do drop us a message. And as we go, we will be monitoring any questions. So a team will be doing that for me. So again, as we go, you can use that question section on the control panel just to drop us a message. And I will look to get back to you after the session. If there should be anything that comes up that might be helpful for everybody, then I'll try and answer it. But otherwise, I'll come back to you directly afterwards. Okay, so let's just have a look at what we're going to be covering today. So we are looking at the topic of Brexit. I'm sure you've heard an awful lot about it on and off over the last few days, weeks, months, years now. But hopefully today we'll be covering some things that you've either not heard about before, or we'll be thinking about it from an angle that's going to be helpful for you as employers, managers, team leaders, and so on. So hopefully you will get something new out of this today. So we do like to give some aims just so we know what we're going to get out of the session. So we're going to begin by having a bit of a recap on Brexit. So if you have decided to take a bit of an ostrich approach and you've been sticking your head in the sand, we'll try and give you a bit of a jargon-free update on what's been going on and where we are at the moment. Hopefully you'll understand a bit about the impact that there has been on employment rights and practices so far. We're also going to consider the effect on legally employing EU nationals in the short term and in the future. And that's it. So, I hope you are ready for this. So let's begin with a recap then, just to get our brains in gear. So if you cast your minds back to the 23rd of June 2016, this was the day when the UK held the referendum on its membership of the European Union. So it was in accordance with the European Union Referendum Act 2015 that voters across the country were asked what we know was a very simply phrased question: should the UK remain a member of the EU or leave the EU? And then on the 24th of June, so the next day, we had the results confirmed by the Chief Accounting Officer. And we got 51.9% of votes, so nearly 17.5 million cast in favour of leave, and 48.1%, so over 16 million votes were cast in favour of remain. So as such, on the 29th of March 2017, the Prime Minister then gave formal notice to the President of the European Council, triggering Article 50 of the Treaty on the European Union, which then commenced the 2-year process of the UK's withdrawal from the EU. And as a result, we went into negotiation with the EU to try to conclude an agreement which sets out the terms of the UK's withdrawal. And I think it's fair to say that the full impact of the UK's decision to withdraw really does remain to be seen. And although the likelihood of Brexit being cancelled is perhaps getting smaller, even if that were to be the case, I think that last statement remains to be true, really. Many industries and even specific organisations have had significant impacts. So there will be continuing ramifications, of this decision on employers and obviously people as individuals as well. So in case you weren't aware of the concept of Brexit, then I hope these few short slides have brought you up to speed on it all. We are now going to have a look at where we are today. There have been many developments over the last few weeks and days, so we're going to have a quick recap at that and focus here. So we were set to leave, of course, on the 29th of March at 11 p.m. So this was the original date and time set for the UK to leave the European Union. However, it was the 13th of March, the withdrawal agreement and the future relationship between the UK and the EU were both rejected by Parliament. So MPs then voted and got through a request for an extension to the 2-year withdrawal period. So with that, Theresa May went and asked for an extension, and she asked originally for an extension to the 30th of June, but that was rejected. And it was there then that we got these alternative dates that you may well be very much aware of. So instead of accepting the 30th of June as the extension, the EU granted the UK an extension until the 22nd of May, but only on the condition that the withdrawal deal negotiated was approved by MPs before the end of March. Failing that, we would have until the 12th of April to tell the EU what we want to do next. So in a bit of an attempt to try and secure that longer date, the one in May, on the 29th of March it was, MPs were asked to vote again to try to approve the withdrawal agreement and the political declaration on the future relationship. But this was rejected, and it was rejected twice. And then in a final attempt to try and get something through, they were asked just to vote on the withdrawal agreement. However, that was also rejected by 344 votes to 286. So this meant that we didn't get that longer extension date, and it does mean that currently, unless something's happened in the news in the last hour or so that I'm not aware of, the default legal position is that the UK will now leave the EU at 11 o'clock in the evening on the 12th of April 2019. So Friday night next week is the night, potentially. So as a result of this, the European Commission issued a statement which I'm going to share with you. And if you look at the last paragraph, I think it is, throughout it, they're expressing regret over the results. And in that last paragraph, they're sharing their view, and it is, of course, just their view, that a no-deal scenario Brexit on the 12th is now a likely scenario. We know, of course, now, though, that on the, I think it was 3rd of April, MPs voted to pass a bill to ask for another extension, and that's what Theresa May is trying to achieve today by going to France and to Berlin. So generally, we expect that they will agree a further extension, a final further extension. So it's likely that will happen, and of course that does indicate strongly a consensus that a no deal is off the table by a very slim majority. So this is where we are now. And on that note, I just wanted to put to you a question. So how are you impacted by Brexit. So you, I mean your organisation or even your industry. And so I'm going to put some options up on screen and you can select any that apply to your organisation or industry. The answers, you know, your individual answers won't be shared with everybody, but it's just to get a feel of how everyone here this afternoon is affected. So I'm just going to launch this and give you some time to digest it and see what you think. So how are you impacted by Brexit? We've got these statements. We currently employ EU nationals. We believe we may have already felt the impact of Brexit, or you believe you have not yet felt the impact of Brexit. Have you actually started doing anything? So have you made some preparations in your business due to Brexit, or are you not yet concerned about making any preparations for Brexit? So I'll just give you about 20 seconds or so just to digest and put in a vote for any that you think apply to you, if you want to join in. It's got about 3/4 of you voted by now, so if you want to join, I'll just give you about 10 more seconds. Okay, great. I've got most people answered now, so I'm just going to close that off and share the results with you all. So we have got a majority of people who employ an EU national at the moment on the session today. We've got a third believe you've already felt the impact, so that's quite significant, and about half think you've not felt the impact so far. And quite a significant number of you then actually have started to make some sort of preparation for Brexit, and just a few who are not yet concerned and perhaps waiting to see how things unfold before you look to take any action. So there has actually been quite a significant impact on most of us who are joining today. You know, certainly you're going to have individuals who are personally affected for those who employ EU nationals. And indeed, you know, if anyone ever thinks that they might do, and of course, you know, that's always a possibility in the future, then certainly there are things we're all going to need to think about there at the very least. So, right, let's just hide that off then and we'll move forward with the next section today. So we're going to move on now to have a think about employment rights that are derived from the EU. So we have got some meaty topics that we are looking at today, and obviously it is a short webinar session. So if you did want to, you know, have more of a discussion about anything we talk about today, then please do, you know, get in touch. That is what we're here for. But we are just sort of introducing these topics today. So to really start to get an idea of the scope of the impact, it is certainly an idea to have an awareness of all the different ways in which EU law is ingrained with ours and how that provides employment rights to us. So just to really paint a picture for how EU law works with our employment rights. So EU law is essentially something that can, you know, and does govern us, you know, and of course taking back control of our ability to set our own rules is one of the key things that was advertised as a reason for leaving the EU. And, you know, it does. EU legislation that comes about really puts in place for us a minimum standard, okay, that we may not fall below. So if it sets rules around employment rights, the UK and any member states of the EU cannot fall below that. It may enhance it, but it cannot fall below. And there are a significant number of ways in which EU legislation is currently integrated with UK employment law, okay. Some really common areas such as holiday, breaks, and a lot of family rights. So maternity, for example, is all something that's derived from EU law. Now, although it is the case that the way it works is the EU legislation provides a minimum standard, I'm not here to really start scaremongering or anything. Of course, if that net, if you like, is removed, then it does mean that a post-Brexit government would be able to amend or remove these minimum standards. But I think it's also important that we do remember that the UK has improved upon many of these standards in the past. Okay, so we don't really have reason to think, that any employment rights are going to regress, depending on your perspective, post-Brexit. Okay, so the UK generally does improve upon these rights. Once we leave, we can amend or remove the standards that the EU have imposed, but that is all subject to any withdrawal arrangements that are eventually agreed and trade agreements that are made as well. Okay. So, there are a number of different EU-derived employment rights, and that was just a small taster, but some of the bigger topics that we're all interested in on a day-to-day basis. Are there any provisions for the imminent future? Well, yes, there are. Okay, so you might have heard about this piece of law. So it's the European Union Withdrawal Act. There are a number of technical and statutory instruments, actually, that have been issued with regards to employment and workplace rights. The purpose of this one, though, is largely to embed most of the existing EU legislation into UK law. Okay, there are some other instruments that do that as well. But pretty much we know that existing rights are going to be embedded into UK law. So this prevents something of a cliff edge, on the day of exit. We also really need to think about case law, okay, and the impact of leaving the EU on that. So, as I said, EU legislation has a significant impact on our law in that it provides a minimum standard. We obviously, have cases that go through tribunals and they can work their way up to a more senior court, as they are appealed. And currently we can send cases to the European Court of Justice, okay, if it exhausts our tribunal system, and we need to go right to the top, so to speak. So there are a number of rulings that have happened in cases at the ECJ that really inform our current HR practices. Now, once we're no longer a member of the EU, it will mean that EU case law will no longer apply, and this has been confirmed categorically, okay? But employment tribunals in the UK are still going to be allowed to refer to case rulings that are made in the EU where it's appropriate, okay? So to help inform our decisions and interpretation of the law. So the potential impact of this is that we could see current practices that have been learned from case law be destabilised effectively, okay, because they will then become open up to UK interpretation. UK judges will be able to interpret the wording of the law themselves, which may differ to how the European Union did it. Okay, so that is something that we'll need to be aware of, and an impact that could happen as a result of Brexit. So we talked about any imminent changes, and I said that we do have some statutory instruments and technical notices, and we've got that Withdrawal Act that are changing employment law, mainly to ensure it continues on Brexit Day, whenever that will be, potentially the end of next week. But we do also have some certainties of things that will change in the event of no deal. So these are specific areas of employment law, okay? So if we were to leave without a deal in place, there are two key areas that are subject to change. Okay, these are unlikely to affect most, but if they are applicable to you, then it's definitely something that you want to find out more about and get some advice on. So please do send us over questions if they apply to you. We're not going to have time to go into detail on it now because it is technical and nuanced, but these are things called Workplace European Works Councils. Okay, arrangements around those are definitely going to change if there is no deal. And equally, if there's no deal, then employer insolvency arrangements will change. Okay, so if you have perhaps contingency plans for becoming insolvent, okay, then you will need to be aware of the changes to these arrangements around the state fund, okay, because that is likely to impact on individuals in your organisation, and as I said, any contingency plans that you have. So these two things are definitely going to change in the event of no deal. So we've had a look at how things are changing in the short term and the fact that, of course, it is going to be open up to the UK to make changes in the long term if they wish. So just want to spend a little bit of time preparing you for how you will implement any changes that might come about in the future. Because effectively, anything that comes up, we will need to take pretty much the same approach, okay, to implementing new practices and policies as a result. So you may be aware that changing terms and conditions of employment is a very significant issue. There are only certain situations in which you're able to do it fairly and in a lawful way. So we would need to identify the correct way to do that. And now thinking about changes to law, okay, one situation in which you are able to change terms and conditions of employment fairly and lawfully is where there's what's called an implied right, okay? And an implied right will always occur where there is a change in the law, okay? But that change has to be one which is more favourable than what you currently offer to your employees. Okay, and that's important. If the law changes and actually reduces what you have to offer to your employees, if you enforced that, you would be making your staff worse off. Even though it's in line with the law, they are used to a higher level of practice that effectively will have become a contractual entitlement, may even be an implied contractual entitlement. Okay, so even though you may change in accordance with the law and make them worse off, you are fundamentally changing their terms and conditions of employment in a negative way. And if you do that unilaterally without their agreement, then you're risking two things. Firstly, a breach of contract claim. Secondly, them resigning and claiming that they've been constructively dismissed. Okay, and that's regardless of whether you are doing something in line with the law, if you're making them worse off. Now, of course, it stands to reason that an implied right would exist where the change in law is more favourable, okay, because you have to comply with the law, okay? You can't make people worse off than what is the statutory minimum. So, in the future, if you keep your ear to the ground and you are aware that changes are being brought into effect by the government that are going to enhance what you currently offer, you will be required to implement this by law, and it will be, as a minimum, effective from the enforcement date of that law. Okay, so sometimes laws come up but they're not enforced for another 6 months or a year, but from the enforcement date it will have to be effective in your organisation. So there may be some prep work that you want to do now ahead of any possible change, you know, just get your ducks in a row, so to speak, you know, because change may well entail you looking at redrafting your policies, handbooks, And you might also want to prepare, staff communication so that you can raise awareness quickly and efficiently and ensure that everybody receives the same message. You may have some groups that are affected and some that aren't, so you might want to be ready for that as well. Okay. So it's not something you would need staff agreement on if you're enhancing their terms, but nonetheless, very good practice to communicate it and make sure everyone gets the same message so there is no confusion. All right. So moving on, it's really important that we have a think about the right to work going forward. So this is a change that will impact every employer's practices, okay, to some extent, and that's regardless of whether or not the UK leaves with a deal, okay, and even in the very least, if you didn't employ any EU nationals at the moment, your practices will need to be ready so you know what to do if you have an EU national successfully apply for a job with you. All right, so right to work. The UK leaving the EU does mean the end of free movement. Okay, free movement would technically end on the date of exit from the EU. So what this means in a nutshell is that EU nationals may not come to live and work in the UK simply because they choose to any longer, but neither can a UK national do the same in the EU. All right, but to prevent, again, a cliff edge effect whereby an EU national, or all EU nationals would have to up and leave, their jobs on exit day, the government have confirmed a transitional period will be in place, okay, or a blanket period. And this is expected to last for approximately 2 years, beginning from the date of exit, okay, roughly 2 years. The exact date will depend on what is agreed. But what we do know in official right to work checks documentation is that right to work checks are due to remain the same until at least the 31st of December 2020. Okay. So during this time, during this blanket period, okay, free movement will continue during this blanket period. And so during this time, EU citizens will continue to have the right to work in the UK as normal. Okay, so people who are here already and people who come to the UK during that time will still be subject to exactly the same right to work checks that we do now. Okay. However then, it does mean that from 2021, an EU passport alone will no longer be sufficient evidence of the right to work, for example. Okay. And that is true of both existing as well as prospective employees. Okay. And what will be evidence of right to work is what's being called a settlement status. Okay. So existing employees and prospective employees would need to present to you that they have a settlement status in order to be able to continue to work in the UK. We're going to talk a bit more about settlement status next, but as you can see, it does mean that right to work checks are set to change. So that is something that we do need to build into our processes, and we will need to basically diarise when this change is due to come into effect. We need to keep our ear to the ground about any agreement that comes out, and therefore, what date is going to be relevant, because we will need to make sure that we've got all the right to work documentation in place. So then, let's talk about the settlement status next. So, going forward, this is a new legal immigration status, okay? And the purpose of it is to ensure the continued rights of those already in the UK, okay? And it will be this which demonstrates their right to work, okay? So the EU settlement scheme is open to EU citizens and their family members to apply to, so that they can evidence this right to continue to live and work in the UK. All right. Now, as employers, don't expect this to be a physical document. Okay. Certainly, currently, it's something that is evidenced online, and there are no talks to suggest that there will be a physical document issued. So it's something that we would have to review as part of an online check in the future. Okay. But as I said, this scheme basically means that individuals will continue to be eligible for public services such as healthcare and access to schools, public funds and pensions, and it's also something they can use as part of their application for British citizenship. So that brings us to an important point, okay, in that the settlement status, it is not the same as British citizenship. Okay, you can retain an EU citizenship and have a settlement status. And the purpose of this scheme, the government have confirmed, is really to ensure that they're not going back on previous agreements that have been in place. We're not trying to pull back on previous agreements to allow, freedom of movement. People who have exercised their right to freedom of movement based on laws in the past should not have that taken away from them because of the decision to leave the EU. So that is supposed to be honoured, which is why I'm going to explain a bit more in a moment, but why this scheme is going to be relatively easy for people to apply to and get a status from who are already here. Okay. So, EU citizens and family members who want to stay in the UK beyond the blanket period will need to apply to this EU settlement scheme. So as I was saying, it's pretty much been, all but guaranteed that if you are a qualifying EU national who arrived before what's called the specified date, okay, then you will be granted a settlement status, all right? Basically, the only way in which you won't get it is if you are a persistent or serious criminal, okay? Otherwise, you're pretty much guaranteed a status. So obviously, this specified date becomes quite important, and unfortunately, we don't yet have a date, which is why I couldn't put one in here for you today. That is subject to any agreement that we do or don't make as part of the withdrawal agreement, okay? But what we do know is this date will not be earlier, okay? It will not be earlier than the 29th of March 2017, okay? So the date we gave notice, and it will not be later than the date that we actually leave the EU, okay? So there's that window there from when we gave notice to leave until we actually leave. So those who arrived before that specified date, whenever it should fall, okay, pretty much guaranteed the status. Anyone who's arrived after that date or arrives during the blanket period, okay, of free movement, they can still apply, but they are being forewarned that you shouldn't automatically expect that they're going to be guaranteed a status, okay? They may well get one, but it is definitely not a guarantee at this point in time, or subject to agreement as part of withdrawal. Now, applications can be made to the settlement scheme now, okay? So, EU citizens who want to continue to live and work after the implementation period, after this transitional period, can start applying now. Okay, they're going to have at least until the 31st of December 2020 to get their application in and their settlement status achieved, but it could be up until the 30th of June 2021 to apply. Okay, and that again is subject to whether or not we leave with a deal. Upon application then, there are two statuses that you could achieve, all right, and they depend on how long you've been resident in the UK. So if you've been resident for 5 consecutive years, then you will be given a settled status, okay? And if you've been resident for less than 5 years, or fewer I should say, then you would get a pre-settled status, okay? If you get a pre-settled status, then you can apply for a settled status once you hit 5 years. And that's regardless of whether or not you achieve that 5 years after exit date. Okay, so basically if you successfully applied for pre-settled status, you will also be able to apply to uplift that to settled once you hit 5 years regardless. Okay. I mentioned this before, settled status is not the same as citizenship, but it can help those who wish to apply for it. You have to have 6 years residence to apply for citizenship, and it's quite expensive to do. But again, people do not have to apply for citizenship if they do not want to. And in terms of employers' obligations towards EU nationals then in this scheme, just to clarify, there is no legal obligation at all for employers to communicate this EU settlement scheme, okay, to their EU national employees. No legal obligation at all. Indeed, employers are warned to be careful not to provide immigration advice unless they're qualified to do so, okay? So we should not feel obliged to communicate this scheme, nor to interpret information provided for the government to individuals who are looking to get settlement status, okay, unless you feel that you're qualified to do so. What you can do, though, is that you might want to utilise this employer toolkit, which the government have produced. So if you haven't seen this already, this is available on the gov.uk website. If you were just to Google EU settlement scheme employer toolkit, it pretty much comes up first for you. I have tried to be helpful. If you have a look on your control panel, if you go to handouts and drop that down, I have linked you to 2 of the pamphlets, if you like, that's on there. So there's a fact sheet and there's also the introduction to the employer toolkit. And on the website, there's all different documents you can download, okay, and print out. So there's things like posters, leaflets, that fact sheet that I've provided there for you. So, you know, you can, if you want to, print those out or get them printed professionally, even if you wanted to, and circulate them about if you would like. Certainly, I know a number of surveys seem to suggest that EU nationals would quite like their employers to be having more communications with them about it, just to recognise that it's an important issue, really, and that we're conscious of it and want to be supportive where possible. So that is a really quite useful, I think, and free resource, which has got some really clear information and, you know, palatable infographics. So, yeah, hope that might be of some use to some people. So we've had a look at what people can do who are currently here, and we also perhaps then should have a think about the future, and that brings us on to thinking about sponsorship. Okay, so once the settlement scheme is closed and perhaps either people have chosen not to apply to it, or they were not eligible, or they've just not thought about coming to the UK until, you know, the future after we've left the EU. Okay, so individuals who do not have a settlement status for whatever reason, if they want to work in the UK, then they will need an employer to sponsor them. Okay, and they will need this sponsorship on a skilled basis only. Okay. And this is in accordance with the UK's future skills-based immigration system that was published on the 19th of December, if anyone wants to have a look at it. Now, if anyone's familiar with the current Tier 2 visa system that we have for skilled but non-EEA nationals. This is the current system we have in place for non-EEA or EU nationals. It's a bit of a cumbersome process. Currently, employers have to apply for and pay as well for a license to be a sponsor in the first place. There's some quite stringent reporting rules that have to be met and adhered to in order to maintain that license. You also have to conduct what's known as a labour market test. So effectively, that's where you have to advertise a role for, I think it's about a month, 30 days in the UK before you look to try and advertise it elsewhere or offer it to somebody elsewhere. There are significant fees for each individual that you wish to sponsor as well, and invariably, as you can imagine, people do face delays of several months, in some cases before an individual can join them. So it's not a very popular process with many employers at the moment. Of course, there are also caps as well. So there are only a certain number of people that are allowed into the country through this skilled basis at the moment each year. So, very much aware of that, the government have said that they are looking to review the current Tier 2 visa system with the expectation that there will be a lighter touch approach. This is a term that they have coined to try and calm any concerns that we might have. Plans include removing the cap on the number of work visas, probably due to some profound concerns about the shortage of workers. They're also looking to widen the skills threshold to include A-level equivalent qualifications, and they're also looking at removing that labour market test as well. So a few different things there that have been publicised already. So I'm pretty confident that those things are going to happen at the very least. I would advise then that if you do use, if you are sponsors at the moment and you use your licence to recruit a number of EU workers or employees currently, or if you think that actually we need to be in the market, of getting labour from the EU in the future, if you rely on a lot of EU national workers and employees at the moment, then it may well be something that you need to think about, i.e. applying for sponsorship. It's very much anticipated that there could be a significant hike in the number of applications for sponsorship when we leave. So, as we can be in this country, and not that I'm being cynical, we can expect that there could be delays in that process for applications for sponsorship. So if that's something that you think that you may need to have in the future, then it's well worth thinking and strategizing about that now. So we're going to wrap up the session today then by just thinking about impacts that we're seeing in the employment market so far. And in this section, I'm using some of the latest figures that we've got from the Office of National Statistics. So fairly reliable information, you might agree. So I wanted to start this bit by thinking about EU workers in the UK at the moment. So up until the end of 2018 then, there were 2.27 million EU nationals working in the UK. Now that is 61,000 fewer than the year before. We know that migration levels for the EU are the lowest overall that they have been for a decade, but generally they are still adding to the overall population of the UK. Now, it was worth comparing this to the figures for non-EU nationals, which is quite interesting. So also by the end of 2018, the number of non-EU nationals actually rose by 130,000 individuals. So let's put that into the context of employment in the UK in general. Okay, so there were 2.27 EU nationals in the UK by the end of last year. Overall, there were 32.6 million people in jobs in the UK. So that's both UK and non-UK nationals, 32.6 million. And that was 444,000 higher than the year before. And this is actually the highest rate of employment that the Office for National Statistics have ever recorded. So that is really quite significant that we've got the most people in employment that there has ever been recorded by the Office for National Statistics. Slightly on a flip side, let's think about job vacancies then. So we've got the most people ever recorded by the ONS in jobs. How many vacancies are there? Well, interestingly, vacancies have continued to rise as well. So employment levels are increasing, but also vacancies are increasing too. So there are 4,000 more in the 3 months to January last year, which meant there was a total of 863,000 job vacancies all together across the UK. So what impact does this have overall? Well, as fewer people are out of work, but there are a growing number of job vacancies, and we've also got EU immigration levels decreasing, as you might imagine, we are developing something that experts anyway in recruitment are calling an intensifying talent dilemma, okay, because there are just fewer people out of work but more jobs available and potentially fewer people coming to the country. Various industries have actually reported concerns about continued business growth, particularly construction and hospitality. So they're concerned that they are already beginning to struggle to recruit, but would also find themselves competing, you know, with their competitors, not only for custom now, you know, and the provision of services, but for talent, for people to come and work in their organisations. So, yeah, they're worried that, you know, they've got growth potential that they've, you know, strategised and forecasted for, but that as they are then, you know, producing jobs, they're struggling to recruit, they're also then potentially and are reporting pressure on things like pay and benefits that they are offering for jobs. You know, they're competing for those out of work, but they're also now competing for those that their competitors employ. You know, so they are thinking about how to re-strategize their recruitment tactics, how they're maintaining their existing talent, you know, plugging the bottom, but also attracting talent both in the UK and in the EU. And of course, for many, that means thinking about becoming sponsors in the future. So that brings us to the end of our webinar session today. I hope you found it interesting. If you do have any questions, then please do send them over. I think we've had a question actually that might benefit everybody. So I've got a question here, which is just pointing out that there were fees. Yeah, so there were fees in place previously for the EU settlement scheme, and just concerns as to whether or not that is still in place for some people. So the EU settlement scheme came in on a phased basis, so it wasn't open to the general public initially. It was open to certain groups, such as some universities, for example, and things like that, who were using the scheme basically to trial it, to test run it, to make sure that it would work properly when it became open to the public in general. And at that time, it was subject to fees. Yes, it was. However, it is no longer the case. it was confirmed by Theresa May in January that it would no longer be subject to fees. So anybody that has paid fees already, if they have applied already and had to pay a fee, then there is a reimbursement scheme open for them to get a full refund. Okay. So yeah, if anyone's got any other questions that they would like answering, you know, anyone who's got questions specific to them, then please do get in touch. Be happy to answer those. We've got an upcoming webinar. So next month I've planned one in on the future of workers. If you don't know the difference between an employee and a worker, then join us for this session. But yeah, we've also got quite significant changes in employment law coming into effect in April next year, which people are going to have to start preparing for. I know I'm certainly thinking about when I'm going to have to do all the work on what that's bringing into effect. And there's also been some this year. So have a think about joining us for that next month. That's going to be at 2 o'clock on the 14th of May. And we've also got some seminars coming up too. We've got 2 sold out at the end of the month. But if you would like to come along to a general employment law update that I'm delivering, then please do come and join us. We've got some spaces available in Kettering still. So if you want to log on to our website /upcoming seminars, you can see that there. That is a free session. And we also have some absence management sessions coming up too, in which we'll be looking at mental health in particular. So come along and join us for those if you're interested. So that just leaves me to say thank you very much then for joining today. I hope you've got something out of it, something that you didn't know before, and found this discussion on Brexit useful, and you've got something to implement. So yeah, thank you very much. Hopefully we'll have you along again another time. Take care. Enjoy the rest of your afternoon.